Hi, welcome to the Fall 2025 It's Your Money and It's Your Estate workshop series, brought to you by our 501c3 nonprofit organization, Financial and Estate Literacy. Our mission is to empower you to take control of your finances, your estate, and your charitable giving decisions. For the past 25 years, our founder, Peter Kote, as well as our entire team, have been providing these free, unbiased, and accessible 6-week workshops all over Orange County, California, as well as online, to help you make informed decisions that align with your unique needs and values. Let's start the program. This webinar is the third session of the It's Your Estate workshop series. The topic for today is Guide to Wills and Trusts. Our moderator is Peter Kote. Our guest speaker is Steve Giammichele. And this webinar is brought to you by the Chalk Foundation. Enjoy the workshop.
All righty. Steve, why don't you come online? Steve, could you put up your Ask First form just for a little bit so people will know that it's there?
Yep, there it is.
There it is.
However, Pete, before you do that, I have a suggestion. Why don't we launch a poll? So we started this last week also. And so here's a poll. The question is, do you have a will? Do you have a trust? Or neither of these? And we're just curious to see what you happen to have. Again, we're trying to be more interactive in terms of what we're doing and get information for us. And it may focus Pete or Steve in terms of where we're going here. I'm going to scoot over here and out of the way for just a moment because I'm going to go over here and answer these two questions. It's not letting me answer. Okay, submit. All right. I was just curious. It wasn't letting me actually submit my answer. And so we good at this point, Pete? We've had most of the people have answered it. I'm going to end the poll and I will share the results so everyone can see that 65% of you have a will, 52% of you have a trust, and 30% of you don't have either one at the present time. So we'll show you why that's important. So thank you.
Thank you, Don.
Now you can go ahead, Pete, and I'll go away. Now you can go ahead with Steve, and I'll go away.
Our attendees have probably, they say more than 50% of the public doesn't have a will or a trust. So our attendees have a little bit more, but we're going to talk about if you have a living trust, you may want to have a will. So we'll talk a little bit about that. Steve, we talked a little bit about that your Ask First form is online, but let's go through it just orally, you and I together. You graduated from law school in what year? Do you remember?
In 2014. Been a while.
So, and during that period of time, since you graduated from law school, what area of law have you practiced in?
In trust and estates, so anywhere from estate planning to administration and litigation.
And then, are you licensed in the state of California?
Yep, I'm licensed in California, the state of Washington, and New Mexico.
And why is that important to know which state you're licensed in?
So attorneys' licenses are generally state specific. So unless you're practicing in federal court, there are some exceptions. But typically, if you're doing like estate planning, things like this, your license is dependent on what state you practice in.
So you had to take a bar in each state in order to be licensed?
Not in Washington. In New Mexico, I could have gone a longer route, but I decided it would be quicker to just take the bar. So I did and passed it, fortunately. But yeah.
Okay. You're also a certified specialist. What does that mean?
Sure. So there's a separate exam that requires you to have a certain amount of experience in California. And the specialty is called estate planning, trust, and probate law. And I am a certified legal specialist in that by the State Bar of California.
How do you charge your clients?
We have different ways of charging. So we have some flat fees if they're starting a new estate plan. We do hourly arrangements for a variety of other things. And on some occasions, we'll do contingency fee arrangements with clients.
Okay. for your set fee for the basic documents, a will, which is more than likely a pour over, a durable power of attorney, the advanced healthcare directive, the living trust, an assignment from the personal property, and maybe a deed change
Mhm.
for their primary residence. Approximately how much would you charge a single person, and how much would you charge a married person?
A single person, full estate plan, I believe, is approximately 3,500. It depends on exactly what they're doing there. And for a married couple, it's about 4,500.
Do you give any free consultations over the phone or in person?
Yeah, we will for estate planning. We do consultations if they request it. We just have a short 15-minute call to kind of discuss what they want, what we do, how the process works.
And then you also do quite a bit of litigation. What is the charge if there's an issue that's going to be litigated?
So if they're litigating, it's generally on an hourly basis, and it's usually initial deposit of 5,000, sometimes more depending on the complexity. But the fees for litigation can get pretty high pretty quickly.
Yeah. And what is your hourly rate?
550 an hour.
550 an hour. Okay. Let's get into your outline. If
All right.
there's, again, if somebody has any questions regarding Steve's fees, please, use the Q&A for those questions. And you are located in Tustin, and
Yes.
which, you know, Tustin is kind of a central area. How do you like your Tustin location?
I like it. I live in Orange, so it's much closer to my home.
That's
Much. We used
nice.
to be in Laguna Woods, for those that don't know. So that was quite a drive for me every day.
Yeah, yes. Uh, let's go to the first slide. By the way,
Yeah.
Steve could, again, just like some of the other attorneys, can give the entire 6 week presentation. We don't want him to do that just so that you have a different flavor of the different attorneys that are in Orange County. There are probably in the estate planning area, I would say maybe close to 200 plus attorneys in Orange County to do estate planning. I'm just guessing, Steve. Do you have any idea?
I don't know the exact number. I mean, a lot of attorneys in general will even say that they do it just as a side thing. But people that regularly practice, I mean, maybe 50 to 100. I
Yeah.
don't know. I've
Yeah,
never counted.
yeah, I never have either. But do you really want to go to an attorney who just does this stuff once in a while?
Generally not. Usually you want an attorney that practices in whatever area of law you need assistance with.
Yeah.
So,
Yeah, they
for
become the
estate
experts.
planning, yeah, if they do estate planning, they'll know what they're doing. If they don't, they may not really know what they're doing or know what to look out for.
Yeah. What do you say to people who want to do their own through LegalZoom or through a paralegal? What's your comment there? We've never
Um,
asked this of an attorney, so you're
so,
my first.
so paralegals technically shouldn't be doing that. Arguably, depending on the state, there may be certain laws that allow them to. Things like LegalZoom, I always tell people if you do it, I mean, it's there, it's a cheap option. I've administered trusts and wills that were prepared through LegalZoom without a problem, but I've also litigated them that created tons of problems because they have standard language and they aren't attorneys guiding you as to what that means. So if things don't go perfectly with how you planned it, you may run into issues that require some sort of court intervention, and that could be just instructions from the court, or it could be litigation that goes on for years.
Yeah, yeah. Uh, because one of the things that you need, especially now with living trust not being tax oriented, at least estate and gift tax oriented, they're drafted based on the dynamics of your family. And
Yeah.
so, you know, the subtleties of having a LegalZoom or a paralegal do it, it's sometimes that language really gets in the way. It could mean a 2 or 3 different things, and if you have to go to court, it's minimum $10,000. I mean, it's just,
Yeah.
and you extend the period of time another, probably more than likely a year. So,
Yep.
what are we going to be talking about today, Steve?
So we're going to be talking about wills and probate and what that encompasses. And then separately, we'll be going over trusts and different aspects of that. So these are just some of the examples of what we'll be talking about there.
Okay, let's go to the next slide.
So first thing is, what is a will? There's a description up there and an explanation of what happens if you don't have a will or if you have a will. And there's some questions that people should really ask themselves if they don't have a will, that I put out there. But basically, if you don't have a will, there's default rules that every state has for what's going to happen with your estate. In California, for example, we have an order of priority as to who gets appointed to administer your estate. If you have assets in different states, it gets more complicated, and you ultimately would have to have a probate in multiple states. If you have a will, doesn't really change that, because the will, whether you have a will or not, there's going to be a probate or some probate administration once you pass away. Whether there's formal court proceedings depends on the size of your estate.
We talk a lot about title. If you're without a will, how do normally people have title to their assets?
So if you just have a will, the title to your assets is just in your personal name.
That's when, and you die, you'll go through probate. We're going to go through the probate process in a little bit. But all of these things, when you die without a will would address, correct?
Yeah. So you can change the default rules with your will to a certain extent. You can choose who administers the estate. That's selecting an executor. The general term for that is a personal representative. And you can also choose a guardian for a minor child if you have any through this. You can also do that through a separate document. It doesn't necessarily have to be a will. But you get to choose how your assets are distributed. And that can be as simple or as complex as you want.
Yeah. There's 3 different types of wills, one of them being a holographic. What does that mean?
Yeah, so a holographic will, at least in California, is a will that is handwritten. So the substantive terms would need to be written in your own handwriting, and you would have to sign and date that document. There's other minor requirements with that, but essentially it's a handwritten will that can be amended to probate once you pass away.
And what is a statutory will?
A statutory will requires 2 witnesses that are there and watch the signer sign it. Usually you see that with forms that are prepared through different companies or through an attorney drafted will.
Yeah, it's a fill in the box type of thing. Make sure if you have a statutory will that you do not change anything on that will, and you complete the questions that are asked in the box. Attorney drafted will. What do you normally draft when you do an estate plan with a will? And I'm talking about the pour over provision. And I don't know if you have a slide on that or not, but
I don't think specifically on the pour over. I think that comes into the trust slides, but the pour over will, all that is it's a will. Typically it's an attorney drafted or a form. It's the same as a statutory will, except the provision for distribution is that all of your assets get poured over into the trust to the extent you didn't transfer those into the trust during your lifetime.
So your will, when you do a complete estate plan, doesn't go into distribution, who you're distributing the assets to.
Yeah, I always tell people you get a will with a trust, the pour over will, because it's the ultimate fallback if you have assets that weren't transferred into the trust and there's no other way to get it in. So unfortunately, that means probate in most cases, but
yeah, but 95%, it's an emergency document almost in your estate plan. If you die with things in your own name, how much can you have in your own name and not go through a formal long probate?
That's on a slide here. I believe it's over 200,000 now under the new. They just issued a new number in April of this year.
Yeah. So you want to know how your assets and how they are titled and what is the market value of those assets. Let's go to the next slide.
Yeah. So if you have a will, like I said, either way, you're going to go through the probate administration process. If you actually go through probate, you're going to open court proceedings, and that can take about 2 years. There's statutory fees with it, possibly additional fees. Everything is public records, so there's less privacy involved with the will, and there's court costs and things involved with that. So on this slide, I have a sort of a description of what those are in California, and that's, depending on how much your estate is valued at, that can be pretty expensive.
Pretty expensive. And it takes a lot of time. And how do you determine what state your assets are going to be probated in?
So it's typically where you're domiciled at, so where you're living. And if you have assets, though, in other states like real estate, then you may have to open a probate in some other state. And that can be expensive. It can be time consuming. It can also just cause further delays because the initial probate that you open where you were living or where your administrator opens it, that would have to continue on in most cases until they call them ancillary proceedings. The probate in the other state is completed.
Yeah.
So.
And you talked a little bit about statutory fees, and you have a description here on the screen. For a $1 million estate, fees are $23,000 for the administrator.
Yeah.
For the executor, are those two words interchangeable? Executor and administrator?
Yeah. So executor is someone who's nominated to be a personal representative under a will. An administrator is someone who's just appointed to administer the estate by the court.
And then the statutory fee is the same for the attorney and the administrator.
Yep. In California, yes.
And then you talked about extraordinary fees. What are those?
So extraordinary fees, it just depends on the circumstances. They're typically awarded on an hourly basis. And so in California, there's certain services that the attorney and the personal representative perform that are considered ordinary services. And there's other services that could be performed that may be considered extraordinary services. So this could be something.
Would be extraordinary. Real estate sometimes is considered extraordinary.
Yep. It depends on the case, but there's pretty much anything outside of essentially bank accounts or securities can be considered extraordinary under different circumstances.
Yeah.
So
why should this be important to an individual, since what we're trying to do is avoid probate? When we do trust administration, do we have to go through all of this?
Through trust administration, the idea is generally that you don't. And that is where title always comes in to play, because if you don't set up a trust properly or properly fund the trust, I should say, you may cause a probate to be needed later on once you pass away. And sometimes even if you title everything, a probate still may become necessary because people are litigating.
Yeah. Families get very upset sometimes at the end of life. Let's go to the next slide.
Sure. So this one's just the explanation of the statutory fees in California and how to calculate it. So if you're curious as to whether it's worth getting a trust, this is the formula that you can add in and see how much the probate would cost if you didn't have a trust. So.
Yes. When families meet with you and they do a will and a trust, they have to pick out individuals within the family to serve as the executor and the trustee. Should that be the same person that they choose for both the will and the trust?
We generally suggest that to people, but people can choose different people in all of those roles. The risk with doing that is that you run into conflict because you have 3 different heads making decisions, at least in theory. So if you have a trustee that's different than an agent under a power of attorney and then a different person making medical decisions, you could run into conflict. But it's also just operationally difficult because a lot of times they'll have to agree and coordinate things, because if one person's in control of the finances and someone's in control of medical decisions, they may not necessarily agree. And a good example of that is like caregivers, right? Um, they may have a big conflict with that, and we see that quite a bit actually.
Yeah. Do normally families allow their whoever is serving in the trustee role or an executor role or power of attorney to be compensated?
Yeah, typically anyone serving in those fiduciary roles does receive some sort of compensation outside of a will. The will can set compensation, but typically it's just statutory fees. Under powers of attorney and trusts, it's usually a term referenced as reasonable compensation. Sometimes they'll have specific formulas for determining the compensation. Sometimes they don't. It just depends on what the document itself says.
So, ways to minimize the need for probate. Own nothing. That's not a good option. Or under the small estate limit. What does that mean?
Sure. So the small estate limit in California, which is here every 3 years now under the new law, they're publishing different amounts. So these are different possibilities if you have estates under certain assets and generally estates under certain amounts. This is issued by the California Judicial Council. So they update it every 3 years. This was just updated this year. So these are the current amounts.
So
if you have, depending on what you're talking about, different numbers will apply.
So it's really important when you say each one of us has a probate estate, maybe, and a trust estate. So we don't want things in our, if we have all the documents, we don't want assets in our personal name over the $208,000. Is that kind of the way we ought to be looking at this?
Well, I mean, yes, sort of.
Yeah.
Because what it is so that's what this slide sort of explains or tries to. You have other options. So not necessarily does it have to be in a trust. So for example, someone may set up a trust, but they'll have a retirement account, or they'll have securities accounts, and they want to designate beneficiaries. Anything that has a payable on death, transfer on death, or beneficiary designation, those sort of operate in the same manner. That is not considered part of your probate estate. That passes outside of probate, and it also passes outside of the trust. And the same thing with joint tenancy with right of survivorship and community property. And so title, again, you'll see throughout this entire presentation, and I'm sure through all the others, title is really important in the probate world, because if you don't have things titled in the proper manner, and the reason for this, and we also have a slide on that, but if you don't have it titled properly, the only way to change title to something, if you're not there to sign to change title, is to get a court order. So that's the real problem. Is it's either going to be through probate or some other court petition once you pass away as an owner that has something in your name that needs to be changed.
So when would you recommend people have a joint tenancy with right of survivorship or community property with right of survivorship?
So community property, joint tenancy with right of survivorship, we generally don't recommend. There's probably few circumstances where that makes sense. In most cases, people have set it up that way prior to speaking with an attorney, or set it up that way when they acquired real estate, for example. That's pretty common. A lot of times you'll see parents acquiring it in that form with their children. And that's because they don't necessarily understand the probate process or trusts or how it all works. But there's a lot of issues with doing that. As far as community property with right of survivorship, that's the easiest form of title to have for spouses that don't have children, or if they're young and aren't too worried about an estate plan. If one of them passes away, it will pass to the surviving spouse.
And you'll receive the step up in basis on the community property
Yes.
with right of survivorship. Whereas
Yep.
joint tenancy, you will not. But the best way for us to have title to assets in our living trust. What is a living trust?
So a trust is really, it's an arrangement between three people in three capacities. It's the trustee who manages the trust assets, the trustor or the grantor, settlor, all synonyms. That's the person who creates the trust. And the trustee is managing the assets for the beneficiary. For most people, when they're setting up a trust, they are the settlor, trustee, and beneficiary at the time they set it up. And that's generally how most revocable living trusts are designed. And the purpose of that is so that operationally, not a lot is going to change in your life while you're alive and maintain capacity. But um, once you lose capacity, you may no longer be the trustee, but you would still be the beneficiary. Once you pass away, you would no longer be the trustee or the beneficiary, but you would still be the settlor or the trustor. That would not change. And the reason that you're all three during your lifetime when you set it up is because you can amend it and modify it as life goes on, as circumstances change, whatever may happen.
Yeah.
So on this slide, we sort of explain differences is revocable trust versus irrevocable trust. And revocable trust, they call them a lot of different things, but in essence, it's just a trust that is revocable and amendable by the person who creates it for their own benefit. And yeah.
So it's important that it's a revocable during your lifetime. Who initiates, whether it's a will or a trust, who initiates the proceedings? What causes, besides the death or incapacity, what event usually occurs?
Well,
For example, somebody needs money out of a bank account.
yeah, well, I'm not sure what you mean by what event occurs. So for a will, it doesn't really take effect until someone passes away. For the
Right.
trust, it's alive during your lifetime, and that's one of the main factors of a revocable trust here is that it survives your death. So it's active and operational during your lifetime, which is why it has specific terms for your benefit during your lifetime. It's amendable, revocable, and then on your death, it's all based on conditional events. So it just depends on what events you set up. Almost entirely, it's the result of a death is what triggers different events to occur in a trust. Sometimes, and we'll get it. There's a slide on that on later on, but you can have distributions set up to be triggered at certain ages. Certain events like special needs trusts, for example, are set up in a particular way.
So basically, a trust is a contract, and in the contract, you state exactly what will happen when.
Yeah.
And so you talked a little bit about that it avoids the court process. Why is a living trust so important in the area of incapacity?
So one of the big aspects of it is that it significantly reduces the likelihood that you may need a conservatorship. It doesn't eliminate it entirely because that's not specifically the role of a trustee. But when you're talking about conservatorships, someone may need a conservator when they're unable to manage their medical or financial affairs. Um, and that could be someone with dementia. They may not have a ton of medical affairs that need managing because they may be agreeable to informal assistance. But if they have nothing set up and title is only in their name on accounts, unless they have a power of attorney, no one is going to have access to those funds to pay bills or to assist them financially. If things are transferred into a trust, it can reduce the likelihood you may need a conservator. Doesn't entirely eliminate it, again, because there's certain things that you can't transfer into the trust, like a retirement account, for example. But things can be set up these days on automatic transfers and deposits. And in some cases, people maintain control over their personal affairs, but they don't want to necessarily manage everything. And so they may resign as trustee and appoint a child or another fiduciary to manage the trust and pay bills on their behalf.
You use the term under the main aspects of a revocable trust. Usually in a trust document that you draft, the first paragraph talks about a little bit of the family history. Why is that kind of important?
So yeah, well, One, it has to do with who has the ability to contest the trust, but it also is helpful for the trustee to know who family members are. They don't always explain who the family members are. Sometimes that could be difficult, particularly when you're dealing with someone who appointed someone who had no idea, like a professional fiduciary that had no idea they were the trustee under this trust and has no idea about family members. And the trust then says, split everything between my children. And good luck finding them, unless they're close by.
Yeah,
But
and it could
sometimes
be
you
a
run into that
second
issue.
marriage. It could be a third
Yep.
marriage. It could be a stepchild. A little bit of history really works well in introducing whoever reads the trust as to what is going on. Then there's another whole section for selecting the trustee, and you use the term trust protectors. Uh, Talk a little bit about what that process is like, or that discussion with a client is like in naming a trustee.
So when you're naming the trustee, as with any of the fiduciaries under these documents, it has to be someone that you trust, that you're comfortable with, that wants to do it, and generally that's capable of doing it. So are they capable of doing it? Do they want to do it? And do you trust this person? And that's the third part is really important. The capability is also important because if you have a lot of complex assets, like a business, for example, and they've never dealt with a business ownership or anything, you may not want to put them in that role. If you don't trust them and you get dementia, that lack of trust may only get worse. And that generally can lead to litigation because, suddenly they don't see you as the friend they appointed under the trust. They may not recall that they even appointed you under the trust. Who knows? It all varies. But that's really what you want to do.
And what is a trust protector?
So a trust protector is someone that you appoint under the trust, and California recently enacted statutes for that. Previously, it was essentially a role for someone to oversee what the trustee was doing. And the purpose of that was primarily when someone lacks capacity and another person is the trustee. They don't necessarily want all of the other beneficiaries to find out about their finances and information. And so the trust protector would oversee and make sure the trustee was doing everything as intended. The scope of what a trust protector can do, it varies. It depends on what the trust document says. You can give them a variety of different powers and authority. And now under California, there is a specific statute that deals with those.
How many successor trustees do you usually recommend?
We usually recommend 2 to 3. Sometimes we may recommend more. It just depends on, a lot of times it's the age or the capability of the person or even their location. That's another big factor too, is where the person's located, right? Yeah.
Can a successor trustee appoint a successor?
You could allow that under the trust. Generally, that is a provision, but it's not always in the trust. That certainly saves a lot of time going to court. So if you've named 3 trustees and all of them are deceased or they just don't want to do it, but one of them or one of the trustees that was nominated says, I can nominate someone for you. If that provision's in the trust, they can nominate someone to serve. No need to go to court. If you don't have a provision that allows that, then you're going to have to go to court to get a new trustee appointed.
Can a trustee do things, let's say, hey, mom said I could make a gift to, if something happens to her, to ourselves as a kid, but it doesn't state gifting is allowed in the trust. Can a trustee do that?
So, can the trustee gift?
Or can the trustee do anything outside of what the instructions state in the trust?
Yes, but so that's the problem with a trust in general, right? And that's where the trust factor comes into play. You don't want to put someone in there that you don't trust that may steal money, because by virtue of having title to the assets and being on title to the assets, they have the power to transfer those assets however they wish. The trust directs them what to do, but that doesn't necessarily mean that they're going to follow those directions. And that's one of the biggest reasons for litigation is that people are alleging that a trustee did something they weren't allowed to do.
So there's an entire section in the trust called powers. What are they and why are they so lengthy?
So the powers for the trustee generally provide language that authorizes the trustee to do pretty much everything with whatever assets there are. And the reason for it is to, one, protect the trustee and allow the trustee to function with third parties specifically without the need of going to court to get specific authorization. There's also default statutes that generally provide powers to the trustee. But it's one of those things where it's more for a liability protection for the trustee, but it's also a litigation deterrent. So you may have a beneficiary that wants to cause litigation, and a lot of the provisions in trusts, at least modernly, they're really designed to reduce the likelihood of litigation over minor issues.
Yeah. And then is the distribution, talk a little bit about the distribution, specific gifts, residual gifts, just the distribution of that trust.
Sure. So the distribution, and we have something here about it, but distribution of a trust can really be whatever you want it to be. I always tell people to use your imagination with the understanding that the more complex that you make distribution under the trust, the likely more costly it's going to be. So one thing that people may have heard of is something called a legacy trust, where you hold it in trust for a beneficiary for the rest of their lives or for some extended period of time. That's fine. You can do that in most cases, or at least have some parameters on there. But that means that this trust is going to be ongoing with a trustee who's getting paid every year. They may have an attorney that's getting paid every year, and there's a tax return that would have to get filed every year. So in theory, while yes, you can do everything, when a lot of people understand, oh, there's actually more to this, and it's gonna be more complicated, they don't generally want to do that. And one of the things is a lot of people will do it like 50,000, and it just isn't going to go as far as you think it will.
Yeah. So do you recommend that people distribute their assets in percentages to their heirs?
I generally don't recommend what people should do with the distribution.
I mean,
Sometimes people will give me
versus a specific amount.
I mean, I don't really have a recommendation either way. Percentages are easier because you're taking a pot. So I just a lot of times I'll just explain the differences of it, right?
Okay.
So it's simpler. Like if you have a specific dollar amount, it's easy to calculate. It's not that complex. If you have some complicated formula, which I have seen, it can get very hard because unless you draft it in a way that really answers all the questions, those questions may come up later and cause the trustee to go to court because someone may say, hey, what about this? The trust doesn't say anything about this issue. And I think the answer is this. And then you have different beneficiaries with different opinions because their interests are affected in very different ways.
Let's go to the next slide.
Sure.
What is a two-person trust?
So a two-person trust is typically called like a married couples trust. It's a trust where there's two trustors, and it's different from a single-person trust in the sense that you have an additional question as to what happens with the assets after the first spouse dies. And that's always a big question for everybody, and it depends on the situation. You have different options. The entire trust can become irrevocable, meaning that the surviving spouse can't change anything. And it might be amendable in certain ways. It may not be amendable. It may be partially amendable or revocable. And then the entire thing could also be amendable or revocable. So this choice, used years ago, it used to be more for estate tax purposes. But these days, this is more associated with blended families. So you'll see when they have kids from different marriages and it's a second marriage or things like that, you usually will see more restrictions after the first death because one spouse will want to make sure that their children are provided for versus allowing the survivor to write out their children. But not always.
Yeah. Do you separate assets as community property or separate property in a two-person trust?
You can. So some people do. It really varies on the situation. So some people will, but sometimes it doesn't matter, and sometimes people don't want to go through that.
When a person receives an inheritance, is that community property if they're married, or is that person's separate property?
It's separate property, um, but even that can change over time depending on how you handle the money and what records you keep.
Yeah. Do people leave money in trust for their children?
Sometimes.
Yeah, good answer. Uh, uh, Give me some circumstances, like a special needs trust. What is that?
So a special needs trust, sometimes called like a supplemental needs trust, is for someone receiving government benefits in some way. So they have restrictions on the distribution so that the money doesn't go directly to the beneficiary, but it could be used for their benefit in certain ways. So
Some
yeah.
somebody has a problem, spendthrift, or maybe have had bankruptcies. Can you put a trust together to protect them?
You can do that. Yeah. There's certain, yeah, you can, but it isn't always going to operate the way people plan. So it really depends. So many of these cases are so fact intensive, right? And the problem is a lot of people don't tell their attorney the whole story. If you don't tell your attorney the whole story, they can't really guide you as to what you should do, because if we don't know that your child has a $10 million judgment against them, you know, we wouldn't even bring it up. We wouldn't even bring this up to you if you didn't want to put it into a sub trust
Yeah,
for them, right?
yeah,
Because a lot of this is directed by the client and what they want.
yeah. Steve, you have a philosophy of keeping it simple,
Yeah.
as much as possible,
Yep.
which is really works in the client's favor. You don't want to make it any more complex than it needs to be. So, but your attorney really does need to know your family situation. Let's go to the next slide. This is a
Sure.
big one.
Yep.
What
So
does funding mean?
funding the trust, it really just means designating or transferring an asset to the trustee of a trust, or transferring it, changing title on it in most cases that's substantive. Not all assets have title, but essentially it's transferring things to the trustee so that it's under the trustee's control, so that the trustee can manage and distribute it as time goes on.
Why should you always have assets that or real estate that's out of state? Why should that be definitely in a trust?
Because if you have real estate outside of California or another state, if it's not in the trust, then you're likely going to have to open a probate in that state. But it depends on that state's rules. Sometimes they may have small. It also depends on the value of the property. It goes back to what one of the slides earlier mentioned about the small estate rules. They vary by state. So, and also the property does, right? You could have 80 acres in California, going to be very different than 80 acres in Kansas. So,
Yes. You mentioned timeshares. Why should you not have those in a trust?
well, so my comment, please don't. Timeshares are always just a nightmare to deal with. Um, if you have timeshares, that's great, but the reality is the cost of it is likely going to be too much later on to collect for the trustee, because in most cases the pro they're usually very low value, right? They're maybe 5, 10, 15, 20,000 at most. Um, and the process is an affidavit procedure, but you've got to work with the different entities. And so even with timeshares, those all vary. And so it depends on when you bought it a lot of times, because the ownership was in a different form depending on when you bought it, where you bought it, and who it's held with. So it could be ownership in real estate, it could be ownership in a company. It varies.
Yeah.
And
You explain chain of title. What does that mean?
sure. Sure. So chain of title, essentially, when you perfect easy example is real estate, right? The chain of title is whoever you bought it from, that person was the initial owner or the prior owner, and you acquired it. You are now in the chain of title as an owner. If you transfer it into the trust, now the trust would be a subsequent owner, and they're in the chain of title.
Give me
Yeah.
an example of a property that's not in the chain of title, and what is the consequences of that?
What do you mean by a property that's not in the chain of title?
Yeah, it's almost has to be in the chain of title, right? There has to be a
Well,
next owner.
well, a property itself has a chain of title. So if it doesn't like essentially that's how you know who owns it. You begin initially where there was some sort of an initial owner and they acquired it and it was transferred subsequently. And so that's one of the things we do end up with litigation is people transfer properties, people do all sorts of things with real estate for whatever reason. Such a valuable asset, you'd think you'd take more time and care with it, but we see some really funny things over the years that people have done.
Um, when property is transferred, uh, you have title insurance. What do they insure?
So they're insuring, well, that's a good question. That that's going to depend on the policy, because, and I'm sure a lot of people that may have experienced those fires initially at the beginning of the year, everyone was looking at their insurance policy to see what exactly was insured. And that is important to know what you have insured. But generally, it's the structure, not the land.
But and when titles change, the title insurance ensures you that you have good title or will defend it at the time if there's an issue.
So yeah, title insurance is generally when you're acquiring the property. You may get it like refinancing, things like that. But title insurance is insurance that they're essentially ensuring that you own the property that you're acquiring, and that's most commonly with real estate.
Yeah. You put in assets that don't have a chain of title. How do those assets become an asset of the trust?
With those, you typically have what's called a general assignment or just an assignment of interest. It's nothing fancy, but it's just a record showing that you did, in fact, attempt or try to transfer whatever it is into the trust. If you do have cash, gold, silver, jewelry, things like that, one cash, I generally don't recommend people holding any significant amount of cash at home because anything could happen with that. And gold, silver, and jewelry, I just suggest keeping a record of what you have. There's
Have you run into anyone who has cryptocurrency as to because they have to have a special code to get in? Have you run into any of those issues?
I have, well, I haven't run into
Or how would you
issues.
recommend handling that? I guess is my question.
Yeah, I haven't run into issues where people didn't have the password
Ooh.
yet. But that's another important thing, right? Is all of your accounts and things like that. They have different programs. I don't know what they all of them are, but various different companies now have systems that you can share with close family members. Like, hey, these are my passwords for everything, right? And obviously, someone you trust. Don't just share it with friends down the street. But you want like a password bank and things like that because that stuff is important. If something happens to you, they're going to need to get into different things like perhaps a crypto wallet or even a computer, right? Because maybe you have a list of all of your assets on your computer and they can't log in to your computer. So, simple things like that. It doesn't have to be, and you can have different lists, right? You can have a list for yourself, as a lot of people do these days, because everything requires a password anymore. But you can have a separate list of just what the trustee or what your fiduciaries may need to know or may need to access.
What about, furniture, clothes, or antiques or that jewelry that's kind of sometimes those kinds of things are a major issue between heirs. How do you,
Mhm.
how do you recommend people handle their personal property stuff?
Usually, well, again, I mean, it
I know
varies
everybody
on
does it
that.
differently.
I generally don't make a recommendation because it depends on what usually people have an idea. I will say that. That's why I don't usually, even for personal property specifically, usually they want the trustee to have discretion to distribute it how the family decides, um, with the trustee having the final say. Because disputes,
That's the final word. You want
yeah,
somebody to have the final say because
yeah,
else you might end up in court. So
yeah.
a trustee has to have the authority to make decisions, and that trust document becomes the legal authority to do what they need to do. If it doesn't state it in the trust, for example, that I can, let's say if I was the trustee for you, if I can't make gifts to the children unless it states in the trust that I can do that.
Yeah. Yeah.
So
And that's always a big issue too, and that's something people don't disclose to their attorney, because it's a private thing. And I don't really know why people don't, but it definitely creates issues later because if you're paying your son's rent or your daughter's rent every month, when the trustee comes aboard, well, they can't just do that because
or
that's giving away your assets.
yeah,
Uh,
or they're having their son or daughter live in their home at rent free.
yeah.
And one of the we're gonna in session 6, we're gonna talk about some of the rules of a fiduciary. But can I just allow a son or a daughter to live rent free in mom's or dad's house?
You can, and then you're running the risk of a breach of fiduciary duty claim being brought. And that's really what it comes down to, right? Is the trustee doesn't want to get sued by people later. And so, that's one of the big things we see is parents a lot of times will help their children out, which is what families do because that's normal. And unfortunately, our law isn't set up in a way that just allows that by default. So
Yeah,
it just depends on what the trust says.
yeah, the rule is that you have to make assets productive. And giving somebody free rent is not productive. Let's go to the next slide.
So this one's how do you transfer? I think we just covered that one. If you can't change title, that's like the assignment there. If they forgot to fund the trust, there are other options. So, for example, if the trustor is still alive and there's an agent under a power of attorney, a lot of times there will be a provision allowing the agent to fund the trust.
You just said an important phrase, and that is, does your power of attorney allow it to happen? So would you need specific language in your power of attorney for the attorney, in fact, to make changes to the trust or to transfer property to the
So,
trust?
yeah, so there's actually a common misnomer, even among attorneys. There's a statutory form power of attorney. I'm assuming you guys covered that in the prior session. The statutory form has, I think it's like beneficiary and trust transactions powers. All that power means is that you can fund the trust, you can withdraw from the trust, um, and things like that. You can do transactions as a beneficiary. But amending and changing the trust is this very specific power that has to be both in the power of attorney and in the trust document. So if it's not in both, then the power of attorney cannot modify the trust. So I guess that's a different issue. But in terms of this for funding, most of them will have that language that allows the power of attorney, the agent under the power of attorney, to transfer assets into the principal's revocable trust.
Well, that brings me to a question that many individuals do a trust and they come to you and 10 years later and say, hey, would you look at my trust to see whether or not I need updating? Most times I'm imagining that you would recommend a restatement. What is that and why is that usually the best answer?
Well, most times when people come to me with that question, I tell them I don't know what that means because in a lot. It really depends on what you want, right? Your trust is designed in most cases to not need to be changed every couple of years. And that years ago, that may have been different because of the estate tax laws. You may have had different provisions and code changes, but at least in modern times, unless you're changing the beneficiary distributions or the trustees, there's really, I mean, you may not need to update it. And that happens quite a bit. It just depends on what the person wants. But yeah, if they're doing a change, it depends on how complex they want it, right? We do amendments if it's a couple of changes. But a restatement sometimes is actually cheaper than an amendment would be because there's less time involved.
And why is that?
So there are forms for a general trust instrument and a restatement, but amendments, there's not really like forms for that because you're changing provisions and you're modifying it. So it just depends on what the person wants to do, because some people want to change unusual provisions in their trust. And that may take a lot more time than a restatement. So,
yeah. What does a restatement mean?
So a restatement is an amendment to a trust that amends all of the terms, and an amendment is just a modification of the trust that modifies something less than all of the terms.
So the benefits of a restatement is that you don't have to change the title to your assets, but you can then change the trust.
Yeah. So if you're doing a restatement, trusts are identified by their original establishment date. So you wouldn't have to modify title or anything like that if you do any modifications to it.
So what is a small estate procedure?
So that was several slides ago, but those were those different dollar amounts that are issued by the Judicial Council of California. They go up every few years based on inflation and I think some other factors. But essentially, they're procedures that allow you to administer assets that remain in a deceased person's name without going through formal probate. And there's very specific code sections on it. So there's certain provisions for like a surviving spouse to collect assets without having it pass through probate. There's real estate provisions for real property of certain values, which just went up this year, but probably won't make a big difference for most people in Orange County. And then you have just general personal property, which I want to say it's 207,000 for some reason, but it varies every few years and it depends on the date of death. So if someone died 5 years ago, you're not going to apply the current small estate affidavit amount. You'd actually apply the amount that existed back then. So it just depends on your situation, but essentially it allows someone to collect them as the trustee without opening probate.
In a living trust, at the end of the living trust, after the signatures, there's usually a schedule. What does that schedule mean? And is it part of the trust or does it have to be updated on a regular basis?
So Schedule A is a snapshot of the day you're signing that document. And that is basically, it's a Schedule A it's a schedule of assets that you intend to transfer into the trust. That schedule does not mean that you have actually transferred all the assets listed on there into the trust. Things that have a chain of title require you to actually change title on that asset to make sure it is an asset of the trust. The Schedule A will help with the third option here, which is a petition under Probate Code 850, which allows the trustee to file a petition with the court to pull assets into the trust after someone has passed away. And even then, that just depends on what exactly they did and what the asset is and where it's located to.
Yeah. So the Schedule A does not need to be changed, but it helps in if somebody has an asset outside of the trust, hopefully to get it into the trust without having to go through a formal probate.
Yeah, I would also say on that, if you have assets outside of California, it may not have any effect on them. So California court orders can only go so far as California's borders. If you have real estate in another state or in another country, California can't do much for you.
Yeah. Let's go to the next slide.
So these are just distribution options that people have. We get a lot of questions, what do people do? What do you recommend? I don't recommend what people should do with their distributions. I don't care what you do with your distributions. Do what you want. But we have seen a variety of different scenarios, and these are just some examples. You can do interval distributions, which is basically conditional events as they reach certain ages. You could have lifestyle distributions, but with the lifestyle distributions, I always tell people to be careful because you can put it in, but that doesn't mean that a court may strike it later because they say, well, this is actually unenforceable because it's some public policy that California has in the future or already has, and you can't enforce it. So just because you say it doesn't mean that it's necessarily enforceable. And then another fun one that people have is an incentive distribution, and those take so many different forms. It just depends on the person and what they want to do. And their circumstances.
But the big one is do you give the check outright to your beneficiaries, or do you put it in some type of a trust? And at what age? That's usually, it seems to be the big questions for people. And there's no right answer.
Yeah.
Don.
Question.
The other part of that, and I don't see it on the list, or maybe you fit it somewhere, and it would be special needs.
That's somewhere here. Somewhere.
Okay,
sorry. That's in a separate spot because those are really unique trusts.
Okay, just making sure.
But yeah.
Because you have to be very careful of what the assets are given to the special needs person or are held for their benefit, such that you don't screw up government policies or benefits.
Yeah, and that's a big one. I mean, we can talk about it now. I mean, special needs trusts, so there's different kinds, and that's why there's a separate slide for it. But there's a first-person special needs trust, which requires a court order typically, but it's assets of a person who's setting up their own special needs trust. With their own assets, I should say. A third-party special needs trust is what you see under someone's revocable trust that they set up for a child. And it has distribution restrictions. And these days, I've even seen them with, essentially optional provisions, right? So some people don't know. They don't know if their child's going to have special needs, and it's a bit of a misnomer, but they don't know if they're necessarily going to need government benefits in the future. And so sometimes there's optional provisions for a trustee that they may have to institute a supplemental or a special needs trust for this beneficiary, but the beneficiary may not need it. And, it also depends on changed circumstances. Some people will have special needs trust set up for them initially and then find out that they never actually qualify for benefits and don't have a need for it anymore.
Yeah. But just talking about distribution, a person needs to understand what not only their primary heirs, but contingency heirs. If something happens to you, do you want it to go down to my children or your grandchildren, or do you want it to go to the other heirs?
Sometimes people will meet with me on these estate plans, and I say they want it to go to their siblings, right? Siblings are older than them; they're 70. Siblings are 80. What do you want to do? What do you want to happen to your brother's share if he dies? I want it to go to my sister. Well, what if she dies? And so a lot of these trust questions it's what you're trying to do when you're setting up a trust is account for events that are likely, because you could go on forever, right, with possible scenarios. But really, you want to focus on the most likely scenarios that may come to pass, because if you haven't planned for that, someone's going to have to go to court to figure out what to do.
Yeah. And the thing of it is on living trust, remember, if you're single, it is from my point of view, you absolutely need a living trust because if you have a trust, you have named a successor trustee to take care of you. And everybody recognizes, institution-wise, recognizes a living trust, and it's very simple. Can you just, if you're the trustee, can you just resign as trustee and allow the next person to step in if you become ill?
You can, if you can.
Yeah, you have to have capacity.
Yeah, and that's why, other provisions in a trust, they have capacity provisions in there indicating what it means to lack capacity. A lot of it is just proper drafting of a trust, and it just
Usually,
depends on what people do.
one doctor says that you lack capacity, or is that usually the case if that in that particular paragraph?
Yeah, 1 to 2 doctors, and sometimes it just depends on the circumstances. But sometimes they don't even need a doctor's letter. They can use even a capacity panel. You don't even need it to be a doctor. You could say, you know what, I trust my brother more than anything, and I want him to make the call when I'm incapacitated.
Yeah.
And there's risks. No matter what you do, there's risks, right?
You want to minimize those risks. Yes, Don.
Hello. And Steve, I think when we talked earlier before we started, there were a couple pages you had removed a while back. Special needs is one you removed because it's not in the presentation.
Oh.
It was in the 40-page version, I believe. I could be wrong.
Yeah, might have been.
What does special needs mean? What does it mean?
So, well, it means generally whatever the trust is going to define it as. But in most cases, it's some circumstance where they're receiving government benefits or entitled to. And
so a
I've seen
child
them
is
be
autistic. They have a major injury. They have whatever it is that they would normally get SSI and other benefits, but they can't if they have assets. Therefore, the trust is set up to help them continue the government benefits and protect the assets.
Yeah, and that's the thing. That's why I always say it's a bit of a misnomer, because it's not always children, and it's not always someone with
very true,
autism or something you would associate with someone that would have special needs, and that's
right.
Those really are complex, and they change every few years because we learn so much more about humans.
Yes, you do in your business.
Yeah, we see so much. It's amazing.
We have today a lot of second marriages. And so, and also prior to the estate and gift tax being so high, 13 million plus per individual, older trusts had what's called the A-B trust, or even explain a little bit, because you mentioned in the lifestyle distributions, what is HEMS and how does that fit in if you are in a second marriage and you want to make sure that your first marriage children receive the funds, but you want income to your present wife, so to speak?
Yeah, so if that's one of those where after the first death, the choice is to split the trust. Usually it's something like 50-50, or 50% of the community assets and each of the separate properties go into the respective subtrusts. But the health, education, maintenance, and support, it sounds like a lot, but all it really means is that it's a provision for the trustee to allow the surviving spouse, in most cases it is the surviving spouse, to maintain their lifestyle as it existed when they were married. It doesn't allow the survivor to enrich themselves and to distribute everything to them, but they can maintain the same sort of life standard that they had.
And then the remainder, when the surviving spouse dies, then the remainder goes to his children of his first marriage.
Yep. Yeah, and even that, they draft them in different ways, but yeah, the essence of it is that you're preserving the assets generally, but you're also not leaving your surviving spouse out in the cold to go homeless or what have you.
Yeah, many a times there are issues with those. Please have an attorney who's familiar with them. And again, you don't want to make your trust any more complicated than you need to be. So keep it as simple as possible. Let's go to your next slide.
Sure. So these are relevant taxes. This is more informative. If you have tax concerns, I always tell people, go talk to your CPA. Find out what exactly you're talking about, because we run into so many issues where people are all upset, and I have it in there. They said there were not going to be any taxes, and it's like, well, they probably meant estate taxes in most cases is what we see. But there's still, potentially a capital gains issue, and that's you run into those issues when you have those B trusts, those AB trusts, because there's issues there too. Because
Yeah, income taxes is more relevant today than
yeah,
estate and gift taxes.
yeah,
So the estate and gift taxes, as you can see in 25 is close to 14 million, 26 starts off at 15 million, and then it graduates up from there. The gift tax, you can give, I believe, $19,000 per year without having to file a gift tax return. You can give up to 13.99 million in gifts and not pay a gift tax. Okay. Um, Capital gains tax. Uh, this everybody's all your assets receive a step up in basis other than IRAs and 401ks, annuities, and the like. And we're going to have an hour and a half session just on those types of assets. What happens to them?
Careful,
Yes,
Pete. Careful, Pete. If you were holding that asset as a joint tenancy, then only one half of it will be stepped up. It's
yes,
community property, then it will be. And
yes.
as
We were
Steve was
talking
mentioning
about
before, if
trust.
you have an AB trust on second death, part of it may not
yeah,
get a step up because it's not there. So
Right.
be
yeah,
cautious of that one.
Yeah. Thank
It's
you,
the
Don.
bean counter talking.
Yeah. No, it's really good point. Income
yeah.
taxes are a huge issue. No
I thought he
longer,
was.
yeah,
I thought
not
he was
estate tax.
retired.
Yeah. Talk about property
You just
tax.
want me to retire and not talk.
Oh, sorry. What,
Property
what was
tax.
your question?
Property
Yeah,
taxes.
yeah. So property taxes, they used to be simpler, and then they were complicated during COVID. So you have Prop 13 and reassessment of properties. Generally, is what's happening these days because the it used to be that there was no reassessment for your personal residence, or if it was going to children, or your up to any other property up to a million, I believe it was. It's been several years now. But they've changed that, and so now it's only your personal residence, and there's a lot more requirements.
So it's
So you
Prop
have to.
19. Is that the prop that's now being followed?
I think so. I
Yeah.
I personally hate
Yes.
referring to the props because I can't remember them, but
Yeah. It's Prop 19.
yeah,
And the issue there is that Don, you have kids and you're probably more aware of this one than I
yeah.
am. But the rule is, Don, what is that rule on personal property? I
When the
mean,
property
your
is
residence?
when the property is when the up value that you would get from an estate tax standpoint is going to become the new assessed valuation. If it is higher than, I believe, if our children chose to have it be their primary residence, then they have to live here, but then they also have a million dollar, not $100 million, $1 million exemption. But anything above that, the taxes will go up. It depends on the value of your house as to whether or not that matters to you. But I'd go into the next slide.
It's
Let's go to the next slide.
so there's not a lot that you need to create an estate plan. Like in our office, for example, we have worksheets that kind of walk you through it all to tell us what you want. But the primary things are those three, those three pieces of information: your name, any names you've used, because we've had people that you may have a maiden name, you may have a former married name, you may have a subsequent marriage. Your name is important because it affects title. The fiduciary names, same thing. Their names are going to be important because that affects title, right? If you have a daughter who got married, you may always know them as their original name, but you may want to bring that up to your estate planning attorney. And the same thing with beneficiary names. You don't necessarily have to change those as time goes on because there's usually a record of someone's name changing, but it's definitely less of a headache if it's already been done, because sometimes people refer to an old name that hasn't been around for 20 years, and it just creates more legwork for the trustee or whoever needs the information.
Next slide.
That's it.
That's it.
And that was good timing.
Yeah, we
Did
got
you
a
like
good
the way that
timing.
worked out that way?
By the way,
Yeah.
we're opening it up for any kinds of questions. Yes, Don.
Before we do that, thank you very much, Steve, for what you've done. Pete, thank you also. appreciate what all we went through today. Hope you guys, there were a couple of things we had in the chats, not a lot of them, but we wanted to make sure you had the opportunity to go through and use that. And we thank you very much for being here. And next week we're going to talk about retirement planning in this section. So we will see you next week. I'm going to turn off the recording